So there's no politics in this. See, this is for the country, for democracy. This is not for A or B. We come to power, some other party comes to power, they'll misuse it. They'll misuse it to your disadvantage. So let's not get into that.
Read 181.
In this case, even the 11th position has not reached, is your argument.
Yes, yes. And this is what is happening, Maharaj. So you won't get the 14-day notice. So then how will you remove him? Now, if you have the 14 days notice, even if it is earlier, Maharaj, then you can't say he's disqualified.
Second proviso, it's a very interesting proviso.
Yes.
Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution.
That's correct. It's a continuing. It's a continuum.
The speaker continues notwithstanding the fact that he was elected through the assembly.
That's correct.
Until the new assembly takes place.
Even in dissolution.
Even in dissolution.
Then what happens is that the speaker vacates his office in the next session when it is reconvenes.
The pro tem speaker.
And then the pro tem speaker, the oldest member of the house normally, is then retired over.
This was relied on by Venkatachalaya to uphold the position of a speaker, saying that he has got nothing to do with the political party, his objectivity is there, despite the house speaker continues. So therefore, you can trust the speaker as the arbiter. That's
we've seen that trust, we've seen that trust being used and misused.
The argument was rejected in it.
Mr. Nariman and my argument was this is unconstitutional, don't give it to the speaker. But it was rejected. It was 3-2. But I think the time has come when you're I really think so. Because this is not about this case alone. These are quintessential questions which will, on the basis of which democracy will survive.
Otherwise, then give it to the speaker, then who will decide?
The court.
Why should the court? It's a matter for the House. That argument was also rejected.
That is exactly what Justice Sibal says in Judgment.
Was that the court should not, because it was argued saying that court can't get into the House to decide.
And ultimately, if you say that this is unconstitutional, then you completely throw the baby out with the bathwater.
Yeah,
there is no disqualification.
Well, there is no bathwater left at the moment.
It's an endeavor of
the Sibal. Otherwise, if you say that, well, the entirety of it goes, then there is no provision for disqualification.
That Parliament will have to make one. The Parliament wants to deal with morality in politics. They will have to make this. This has to be done. Now, how we make it, what is the contours of that legislation?
You don't have to go to the extreme of it.
No, I'm not. I'm only saying, to your lordships that this is the...
Let's draw a line there, Mr. Sibal, or else it will become unending.
It will become unending. And there has to be some constitutional certainty also.
But then you must lay down a law, that there is some certainty, because otherwise, what is happening is, that these matters are never heard. Your Lordship knows adjournments are granted every week, for years. For years, these matters are not heard because the Speaker is sitting there. And we come to court and the court doesn't...
But therefore, your argument on Nabam really is that the constitutional scheme does not contemplate the disqualification of the Speaker merely on the issuance of a notice, or for that matter, even upon the grant of leave accordingly.
That's right. 189 says that if there is equality of votes, then the casting vote is for the Speaker. But when his resolution for his removal is in consideration, he can only vote at the first.
When do the words under consideration kick in?
Kick in at the time when the motion is moved for consideration.
Is that so, or does it kick in the moment leave is granted to move a resolution by 29?
No. But the resolution may not be moved, as I said. No.
Still remains under consideration.
Yeah. Because then he can't be the Speaker, Then how can he sit on that chair?
And how can he? No, he can't be the Speaker in the meeting, correct? Or the day on which the actual resolution is taken into consideration.
Yes.
Taken up for consideration.
Absolutely.
That is what you are submitting.
That's right.
Otherwise, under Rule 11, he cannot act.
Because otherwise he can't act, grant leave.
Interestingly, both Clause 2 and Clause 1 is the expression under consideration.
Yes.
Now, conceivably, the word under consideration in Clause 1, words under consideration in Clause 1 may not only be relatable to the date on which the resolution is taken up for consideration.
That's right.
In Clause 1. But in Clause 2, it is obvious that the words under consideration operate on the date when it is actually taken up for
That's right.
So the question is whether we should therefore expand clause 1 and say that under consideration in clause 2 relates to a different point of time than in clause 1. That's a possibility.
Well, it's my respect for...
According to you, it should be the same.
I'll tell your lordships why. The word consideration is not a word of art in clause 1. It is a word which relates to the procedure of the heart. It's not a word of art.
Because
under consideration
says that you have a right, he has a right to speak when it is under consideration.
Yes.
Now, his right to speak is on the motion when it is.
That's correct.
Therefore, according to you, under 1, where he is not entitled to precise, this will attach on the date when the motion is taken.
The reason is, Manas, the word consideration is used in the context of procedure when his removal is being considered.
So according to you, therefore, even when leave is granted, the stage of the threshold of leave is crossed, even then he can really preside.
There's a judgment, Manas, of the Allahabad High Court to that effect, which I showed to your lordship.
Goes with the word sitting.
It goes with the word sitting, Manas.
Is this scheme of 179 and 181 any manner affected by the 10th schedule?
No. This is our case, Manas. It can never be. These are proceedings in the House. These are legislative proceedings in the House.
The 10th schedule is silent on what happens when there is a notice.
It can't, Manas. In fact, the 10th schedule, there can be no pause, Manas, because it's a constitutional authority. There can be no higher, as I said, Manas, that's the base. It's a fundamental principle of constitutional law. Whether it's the Election Commission, the government, the Speaker, Manas, the courts, there can never be a pause. It's anathema to constitutional...
relating to the presiding officer of the tribunal's competency.
Yes.
They only relate to those two.
Yes.
So 10th schedule to that extent will have no bearing.
Doesn't apply. Because it's in the House. We're talking about his removal from the House.
Presiding officer. It's about his...
The flip side, if we permit a speaker, now you're assisting the court as counsel.
Yes.
Not really...
Yes, of course.
Because we're looking now at a broader constitutional issue. What would be the consequence if we allow a speaker to participate? There are two stages, right? One, just the notice. The notice is, of course, it can be given even by one person. What would be the consequence if we don't allow the speaker to take action the moment a notice of resolution is issued? That, according to you, would result in a very serious consequence. But on the flip side, what would be the consequence if we allow the speaker to participate even when the stage of, say, the grant of leave is crossed? What would be the argument on the flip side?
No, but there have to be 29 members have to support that. He cannot decide.
No, 29% MLAs have already supported, and the leave is granted.
If they've supported others and leave is granted.
Correct.
Mr. Chief my brother will explain what was falling.
Was asking you is, what will be the consequence of the speaker continuing to decide the 10th schedule proceedings while a proceeding is pending after issuance of the notice?
As I said,
that's the question.
Yes, as I said.
Other line of, this should be seen in the context of other line of judgments under 10th schedule, saying why is he in such a hurry to decide? There must be sufficient time.
Let me Milad, answer that straight away, Milad. Now, you are interpreting 179 to mean that the speaker will continue to discharge his functions as a speaker till the motion for his removal is put to vote.
Correct.
The purpose of considered.
Correct.
Correct, Milad?
Correct.
He has no disability.
Correct.
Correct? And till it is put to vote, the motion will never be moved. Will never be moved, Milad.
So,
Mr. Sibal, what is worrying, of course, is sorry, Nasma.
No, go ahead.
Now the only point is this, that by giving the power to a speaker, are we then going to essentially give the speaker the ultimate power to decide upon the course of his own removal?
No, it's not the course of his own removal, it's the course of the removal of those who have actually voluntarily given up membership of the party. This is not a question of course of his own removal.
Yeah, that's because
he will tilt the balance.
I'm sorry?
That may tilt the balance.
But it will balance. If they have voluntarily given up, it will tilt the balance. Why should it not tilt the balance? Why should it not tilt the balance? If actually, kindly forget about, now let's go into just a a short summary of facts. In this case, what happens? In this case, what happens is this notice is given. This court says they can reply by 12th of July.
Right.
And the government falls in the meantime. And we are 8 months down the road. He has not even given notice on our disqualification petitions.
Move the notice.
No, the person has not moved the notice and the speaker has not given a notice on disqualification petitions. I mean, you have seen the
So according to you, the speaker was well within his right to disqualify anybody in the meantime as well.
because of the facts which are undisputed. You had a new government with the support of these people. What else is it but voluntarily giving up membership of the party? And then, Manoj, if the argument is he is going to decide his own fate, no.
Now, Mr. Sibal, we saw the first part of Nabam Rebia where Justice Keir puts it as a matter of ethical grounds. Now, how does he interpret?
Yes, I was going to read that.
Let's just
we'll go for
so that's the next step to cross on Nabam.
Yes, absolutely.